appears the conversation around the controversial e-levy is not staying away from mainstream media conversations following the latest commentary from the majority side of the legislature. That's because the majority leader, Oseche Mensah Bonsu, has described the filing of an injunction against the implementation of the e-levy as an exercise in futility. Now, 3 minority MPs have filed a case at the Supreme Court seeking to arrest the implementation of the controversial levy following its passage and subsequent assent by the president. The majority leader, Oseche Mensah Bonsu, says the minority had no right to go to court, and is questioning the decision when all avenues in Parliament has not been explored.
We want to stop. I think the finance minister indicated to us that the commencement of the collection, right, is going to be on May 1st. That's what they want to. I don't know what they say. They want to stop the implementation, but the bill is already being implemented. I don't know what they mean by that. Upon the assent of the president, a bill, if Parliament has not postponed the operation of the bill, immediately after the assent, it comes into operation. So if you fall foul to it, you can be prosecuted for falling foul to a bill that has been assented by the president. So this bill is in operation. The necessary structures are being put in place now. It doesn't mean that it's not being implemented. It's being implemented. If the minister tells you that the actual collection will start from 1st April, 1st May, and you think that it's not started, so you want to put impediments in the way before the commencement date. I don't know what the understanding of the commencement or the implementation of the bill is. So that is it. But I think that we are beholding some dangerous spectacle.
That's the majority leader, Oseche Mensah Bonsu, speaking to the parliamentary press corps earlier today. Let's get on the phone and speak to Roxy Nelson Dapiamekbo. He's South Dye MP, is joining us for a quick response to this. Many thanks, Honorable, for speaking to us. The majority leader, Oseche Mensah Bonsu, he contends that the minority has failed to exhaust the procedures of the legislature before going to the courts. The question really is, why has the NDC MPs done this if they are truly processes to address your concerns?
We should have asked the majority leader what are those available procedures in Parliament after the passage of the bill into a law. We should have asked it. Once Parliament passes a bill into a law and the act is assented to by the President, it leaves the remit of Parliament. Unless a new bill is introduced to repeal that law, it's gone. So I am struggling to appreciate what procedure he speaks of, which he thinks that is available for the minority to exercise, to be able to, as it were, arrest what has been done. There's no such procedure. And let me also say that why does the NPP think that anytime the NDC or the minority exercises its rights under law, for instance by going to court, they label it as an impediment, as placing an impediment in on the part of government. But when they go to court, then it is their right to go and exercise in court.
You find that challenging?
No, I'm struggling to appreciate that. No, we don't have rights under law. We are saying that the procedure adopted between the adoption of the report on the e-levy and the subsequent consideration of the provisions on the floor, leading to the third reading, leading to the passage of the bill into law in Parliament, was unconstitutional. That is what we are saying. And anytime you are saying that something is unconstitutional, you don't say in Parliament extension. The problem is the Supreme Court. So the minority, the majority leader and the MPP to understand the distinction here. What we are speaking about is about a breach of the Constitution. And a remedy for breaching the Constitution doesn't lie with Parliament. It lies with the Supreme Court. So that is where we've gone to. And he says that the Supreme Court hasn't got the power to injunct the implementation of the law. Who told him that?
Well, his argument is that the law...
Hold on. I heard him clearly, so let me address it. Who told him that? The Supreme Court has the power to even strike down any law that has been passed by Parliament that is unconstitutional. A whole law, a whole gamut of laws can be struck down by the Constitution on grounds of nullity. Portions of laws have been struck down by the Constitution, by the Supreme Court, on grounds that they were unconstitutional. So we want the majority leader and his majority members of Parliament to appreciate the fine lines in the law here. Two, it is also not correct that the e-levy is being implemented. They have suspended the implementation. The implementation will take effect on the 1st of May. What they are doing is to put in place administrative processes. That is not the law. So if Parliament doesn't give you power to suspend the implementation of the law, but you, the executive, chose to do so, who says that the Supreme Court cannot injunct it? So they should stop interfering in the work of the Supreme Court. When they say some of these things, and then they fit into a certain perception, then they say that we are not being fair. I was expecting him as the majority leader and leader of government business to say that once the minority have gone to court and have brought a motion properly so called on notice for an interlocutory injunction to be granted, he will want to leave it in the hands of the Supreme Court to deal with on the 4th of May and not to run commentary. So if tomorrow on the 4th of May the Supreme Court says they refuse our injunction, you think the NDC wouldn't have cause to complain?
Does it worry you in the minority, these commentaries that's been coming? You mentioned one already, that he cannot say that the Supreme Court cannot injunct the law. So does it worry you? Does this argument of a perception that's been created?
It does worry us, because we have had too many from them. You were in this country when they told us that they will make sure that the honorable Christie is injuncted. It came to pass. They told us that they will make sure they will use the court to remove honorable Christie from Parliament. It came to pass. So when they say some of these things before the court comes to a decision, and it dovetails into things that they have said ahead of time, how do you expect me to reason otherwise than to conclude that there's something happening? So we beg of them, when we have matters before court, they should leave the court to handle it. Then we will be in the position to do an ex post facto analysis of the decisions of the court on its merits. When you begin to run down my application on notice as being frivolous, when I have a substantive matter in terms of interpretation of Article 106 and other provisions regarding the procedure adopted by Parliament after we walked out to adopt the report and proceeded to consider the provisions of the law and pass and read it the third time and pass it into law, infringing 106 the procedure, infringing 102, infringing 104 of the Constitution. When we make this allegation, these are very serious matters of law, and they are pending before the court. The court recently said in the injunction that was granted against Christie that when a party alleges a breach of the Constitution, it is the entire interest of the country that is at stake. That is the overriding interest of the country. Even the interest of government, the interest of the republic overrides the interest of government, because the state is bigger than government. So the interest of the executive cannot override the interest of the breach when a breach of the Constitution is being alleged.
So for you,
having made this argument, the Supreme Court recently made this argument for Kulendi GSC. So the majority leader should be patient for the date set for 4th of May for this matter to be determined.
You call on him to be patient. Let me let you in on another matter that's been in the media space in the last 24 hours. It has to do with the commentary by the Attorney General on cases that are brought before the Supreme Court. He seeks to admonish the justices not to allow frivolous suits come before them. They do not sit before frivolous suits, and that they allow only cases that can result in law changes rather be heard. I mean, your thoughts on this, or what meaning you read into these comments?
I have already reacted by saying that the Attorney General's comments are embarrassing the judiciary. Any student of law, any lawyer properly trained anywhere, and particularly in our jurisdiction, knows that it is fundamental for a court to determine the relevancy of any case brought before them, including whether or not the jurisdiction of the court has been properly invoked. And so, for the Attorney General to use a platform organized by the Ghana Bar Association to talk at the Supreme Court judges that when matters come before them, they should, when they consider them frivolous, they should dismiss them in chambers and not even come to sit in open court. It's condescending, because that is what they do. Look, it's a prerequisite of the judiciary, properly so called, to determine the local standard of any applicant, any plaintiff before them. They determine the merit. So if they don't do that, how will the cases be listed? So it was totally uncalled for, totally avoidable, totally unnecessary for the Attorney General to talk at the Supreme Court judges in the manner he did. It creates the impression that that is not being done. It creates the impression that the Supreme Court has become like a district court. That is the kind of impression it's creating, where all manner of applications are filed and all manner of frivolous applications are filed. But that is not the case. It is only in the Supreme Court that even when your matter is dismissed, they will have to give you a reason. They tell you why they refuse an application. And the fact that an application is refused doesn't make it frivolous, because they would have stated the reasons in law. In our type of jurisprudence, which is the common law jurisprudence, there are always a gamut of laws supporting whether or not the matter will prevail or succeed before a court. So we don't practice the civil law jurisdiction or jurisprudence.
Right.
We practice the common law jurisprudence. So you can always have a set of laws to be in support of a case, or a set of laws to be against a matter before a court. That is why you always have lawyers for defendants and you always have lawyers for plaintiffs. That is why even in criminal matters, you have prosecutors who are prosecuting an accused person, and you will have defense lawyers who will be canvassing law to ensure that the level of prosecution that is being brought, the charges that are being brought against the accused person will not succeed. That is our jurisprudence.
Right.
So the Attorney General should slow down. He is too hyper. He should slow down.
Right.
And allow the court to do what they are best known for.
Right then.
In adjudicating justice, adjudicating matters, and bringing justice to people who come before them.
Honorable, I appreciate that you could speak to us this evening.
It's my pleasure, my brother.
That's the Honorable Roxy Nelson Dapiamekbo. He's South Dai MP, speaking to us this evening. First off, in reaction to comments by the majority leader that their injunction application is not necessary in essence, and also reacting to the comments by the Attorney General yesterday during the opening of the Ghana Bar Conference. We'll move our attention from matters of law and talk politics now, because the embattled chairperson of the Convention People's Party. Nana Akosua Mpoma Sapon Kumenkuma has described as illegal a party directive asking her to step aside. The Central Committee of the party, through a statement, ordered the chairperson to relinquish her position to make way for a rerun of the chairperson election on the grounds that she failed to garner the required votes at Congress to be duly elected as such. It said Nana Sapon Kumenkuma obtained 43% of the total votes cast in the chairmanship or chairperson elections of August 2020, which does not make her qualified for the position. To rectify what the committee considers as an anomaly, there would be a rerun of the election between Madam Kumenkuma and Hajia Hamdatu Ibrahim, who was the first runner-up in the elections. But the chairperson says she will not step aside. She's been speaking to 3FM.
The CPP has its constitution. The general secretary of the party, already she's been interdicted. Even if she wasn't, by our constitution, as long as we have a chair and leader here, you can only take instructions. That it means that I would tell you to call a CC and you call a CC. You do not go by yourself to go call a CC. You don't call other group and say that they are executives and therefore you can overturn the decision of the constitution for you to. You don't. Indeed, did you know the interesting part of what is happening? The supposed CC that was called today, outside the 8 executives who are part of me that were sworn in by the same council of elders who apparently don't want to listen to anymore, every member who was there today was sworn in by me. If you challenge my position, you are challenging the entire CC. So that is the mockery of the whole thing. That is why it is important that if there are issues, you go to the internal structures. And by the time you go to the internal structures, then you will have found what needs to be done. But when you get up and say, no, I don't want this president, so a group of us will get up today and declare ourselves, it doesn't work that way.
So that's the embattled chairperson of the CPP, Nana Akosua Mpoma Sapon Kumenkuma. Let's get on the phone and speak to the Director of Elections for the Convention People's Party, Habib Yakubu, to have an understanding of happenings in the party. Many thanks, Mr. Habib, for speaking to us. We've heard from the Central Committee ordering a rerun of the elections. You're the Director of Elections for the party. Are you ready to undertake a rerun, and how soon is this supposed to happen?
Yes, good evening, and permit me to use this opportunity to say good evening to our listeners as well, and also granting me the opportunity to at least set the record straight and bring you the facts as it is. In the first place, the caption or the heading of the presentation that we are having now is misleading and it's not the facts as it is. There was no Central Committee of the Convention People's Party as stated. Let me debunk that one straightforward. But that's a group of people or supporters of the party who met. And that kind of meeting clearly affronts the CPP constitution because it fails to meet the standard of what we call Central Committee. Secondly, that was an act of insubordination and a misconduct to the highest standard as per our party constitution, chapter 4, the disciplinary act of the party. This meeting that was held yesterday has no veracity and can never be called the Central Committee. Now, let me move forward. The party, as per its constitution, the Central Committee is always convened when the chair and leader is seated. Secondly, in the absence of the chair and leader, when the chairperson is not within the jurisdiction, how come you have a chair and leader? You set up a Central Committee discussion. That's why I don't want to call it a Central Committee. That for the General Secretary will purport, call some few members of party to sit and call it. It was not a Central Committee meeting. So that was taken there clearly was not the position.
So there wasn't a central committee meeting, and so there's no directive for a rerun of the elections. But what is in contention right now?
Yes.
What is right? So what is in contention now is the position of the chairperson of the party. The argument is that she didn't garner the required vote. She garnered 43%. As such, she isn't supposed to be the chairperson of the party.
Right.
The director of elections.
Let me also deal with that in an emphatic manner, without using the same Convention People's Party in a discriminate approach. The Convention People's Party, per our constitution, that was amended in 2011-2012. Our party has been in the compromise position. I use the word compromise because since the party amended, the Convention People's Party constitution was amended in 2012, we've never been able to go by the tenets of the Convention People's Party, which is the spirit that operates the party. Why am I saying so? This issue of 50+1, if you ask those people who are parading themselves, running amok, disrespecting and denigrating the parties in public, that how were they themselves constituted? Because if you want to take that, then you need to talk about the basis of how the CPP has gotten to where we are today. The Central Committee that was in place was challenged by Dr. Kuti, who was the legal head of the party in 2012, simply because the party is not properly organized per the Constitution. And these provisions of the Constitution are so entrenched that you can only go to National Delegates Congress to be able to amend them. But the party has been in this compromise position because we've not been able to organize our polling stations, electoral area, and the constituencies properly constituted to even have a national to have delegates to go and elect.
So the case is that the party has not followed the constitution of the party by the letter, and as such, nobody can lay claim to any of these.
Absolutely, yes. And I want to come to what has happened, why we are in this situation. Now, fast forward. When these COVID coronavirus issues broke out and all those things, as you know, it's been out of power for so many years. There's financial constraints. The party was also in court. The Council of Elders have to come in to take the party, to take the case out of court because Dr. Kuti challenged the legitimacy of the density central committee because of the lack of capacity. So they brought the case out and then set the constitution aside. Then we have what we call IOC. In the constitution, there's nothing called IOC. Okay, there's nothing called IOC. So by doing so, meaning that the constitution is set aside so that we could go in this compromise position and have an election, so we can actually run or contest in the general election.
So just briefly for me, it means all of these allegations are what? Unfounded, they have no basis, and as such must be disregarded. Is that what you're saying?
Absolutely, totally disregarded, because you see, the Council of Elders came in to do this because they want us to be able. So these people who are in the capacity of leadership today have the opportunity to organize the party, and that is why they thank the current leader actually hinge on Article Constitution. That which says that when the party is in opposition, you should be able to put your house in order and do your elections 2 years ahead, 24 months ahead, before the next general election. And for us to avoid the zeros, I mean, you are a principal witness to the way abysmal performance of the Convention People's Party in the last election. And we must start from somewhere. We must be serious. We must speak ourselves relevant for Ghanaians. That is why the current chair leader in the position of the Convention People's Party today, in our compromise position, said, so, that is now. It's about time we make a move. Let's go to the drawing board. Let's start. We must relevant to Ghanaians today.
Right then, I appreciate that you could speak to us this evening. That's Habib Yakubu. He's the CPP Director of Elections, speaking to us here on 3FM. It's now time for the latest in the world of business. My colleague Grace is joining us with the details. Grace.
Thank you, Mawuena. Welcome to Business on Hot Edition on 3FM 92.7. My name is Grace Mawuena Edgeta. Let's go straight to it. And beginning tomorrow, Saturday, April 23, 2022, All Glo Mobile customers in Ghana will be moved onto the Airtel Tigo network. This is contained in a circular from Glo to its over 800,000 customers, informing them about a strategic partnership between the telcos. The circular read, in a bid to provide wider coverage and a faster internet experience for its customers, network operator Glo has entered into a nationwide national roaming arrangement with Airtel Tigo for voice, data and SMS services. The circular urged Glo customers who face any difficulty in automatically latching onto the Airtel Tigo network to manually select Airtel Tigo network in their phone or device's network setting and enable data roaming and a mobile data network setting to enjoy superior experience on the Airtel Tigo network. So that is the latest there. But to other stories, director at the Institute for Statistical, Social and Economic Research, ISE, at the University of Ghana, Legon, Professor Peter Korte, has backed calls by the International Monetary Fund for Ghana to establish a credit committee to restructure the country's unsustainable public debt. He argues close to 50% of tax revenue used to service debts is unsustainable.
The suggestion is certainly in order. If you look at how much we spend to service our debts, close to 50% of our tax revenue is spent on servicing debt, and that leaves us very little after paying for wages and salaries and compensation as well as statutory payments. We are virtually left with very little to undertake any development expenditure, and if we don't to invest, we then continue to borrow. So restructuring our debt over a longer period, and also to ensure that our repayments are reduced, then we'll have the fiscal space to be able to undertake some of the activities that we have plans to do. Currently, there's the cuts in expenditures and all that. And as much as we are trying to raise revenue, I think that would also help if we restructure the debts and debt service amount spent to service debts.
Professor Peter Korte is director at ISE. That's it for Business on Hot Edition. My name is Grace Hamwa Ajiman.
Many thanks, Grace. With the latest from the world of business, we'll do a quick trip to the Ashanti region because there's an easy calm at the Mawuena constituency of the governing New Patriotic Party as a group supporters there besieged the office following the opening of nominations for upcoming polling station elections. William Evans Inkum is a man on the ground. He joins us on phone. Evans, give us the details. What's causing this latest agitation by party supporters there?
Well, so they have been told that party nomination forms will be ready in the early hours of Friday, that is today. They came to the party office around 6 a.m. hoping that they will get nomination forms for the first time contest for various positions as far as polling station elections in the Mawuena constituency is concerned. Only for the representatives from a national executive council that is the CEO of UPA, Henry Kokofu, to engage in a marathon meeting with the constituency executive. So around 12 p.m., there was still no eyes or as far as leads as to when the forms will be released as far as that particular constituency was concerned. It was only 3 p.m. that the forms were released, and they were saying that these were just tactics by the national executive together with the regional executive just to deny party members of the constituency the forms or various positions as far as compilation of the album or the party's album is concerned. Mind you, the constituency has come under a lot of criticisms and of course issues stricken as far as internal politics within the Mawuena constituency is concerned.
Right.
It started with the perception that party machinery is working just to get the party out to the independent candidate who hasn't gone through the process of reintegrating into the party. So that is it. At the end of the day, they rejected the forms. Even at the tail end of the persuasion, at the point in time they had to be coerced, and few people take the form, but they are not even sure of returning the forms.
Right then, many thanks, William Evansinkum, a bureau chief in the Ashanti region, providing details from the Mawuena constituency. That's our package this evening and for the week. I am Eric Mawuena Edgeta. Don't forget, it's a weekend, not a long one like the previous one, but I'll trust that you enjoy yourself and take care of yourself. Have a good evening. Bye-bye.